Steve is an attorney with a firm of Foster Pepper in Seattle, and he's been working with cities for over 30 years. He focuses on litigation involving state and local governments, land use, and environmental law. His experience is vast. It includes representation of jurisdictions on eminent domain, utilities, local improvement districts, facility siting, and contractor litigation. Steve has been instructing local elected officials in this workshop for 20 years now. It's my pleasure to welcome Steve to the show.
Thanks, Mike. Good morning, Chewelah and everywhere else. I want to particularly acknowledge some old friends in the city community, Marie Mosley and Ken Hohenberg in Kennewick, Benson Wong from Mercer Island, Brian Holzclaw from Mill Creek, and here in Olympia, Joe Pestinger, the new Ording mayor. Today, we're going to talk about the basics of government. In some respects, civics lesson for all of you. The handbook is the Knowing the Territory that you have in your materials that is published by MRSC. And I'll give a quick shout out to Tracy and all of her staff at MRSC for the wonderful job that they do. It is not uncommon for me to go into the office in the morning, turn on my computer, check my email, and then log on to the MRSC website because it gives me one of the most convenient accesses to the laws, the Administrative Code of Washington, and court cases. So be sure to take advantage of that opportunity. You also have the evaluation materials as well as a question and form if you're here in Olympia. For those of you who are not in Olympia, you've already been briefed and can send in your questions through your facilitator. We already have a dozen or more questions, some of which we'll be discussing throughout the day. Others we'll try to save time at the end to address. So don't hesitate to send your questions in, particularly if you haven't had the opportunity to have them answered. Although I will say, many of you were elected with burning issues that will not necessarily be resolved today. So just to be assured that we'll answer as many questions as we can, but we're not going to answer all of them. Mike did not mention that one of the reasons that I'm asked to do this program is that I'm politically neutral. My eldest daughter graduated from Washington State, and our son graduated from the University of Washington. The thing that we're not going to have time to do today is to tell a lot of jokes, unfortunately. I will read a headline from the Seattle Times via the Tri-City Herald from 2005. Benton County Commissioner fined $268 for shooting a skunk under the courthouse. You know, we see headlines like that, and we'll talk about some more of those throughout the day. And the best way to summarize humor in this business is, as Will Rogers, that great American humorist, stated, "I don't make jokes, I just watch the government and report the facts." For the lawyers in the group, just one other matter of housekeeping, 3.25 CLE credits, and be sure and sign up with your facilitator. We're going to have three parts basically today. We're going to talk about the authority of cities, your cities, and then in part two of the program we'll be more focused on how you get things done. You know, who does what and where and when. And in the third part of the program we'll get down to some hard work on ethics and some of the restrictions that exist in your realm that frankly don't exist in many places throughout the rest of the country. When we talk about authority, we must begin with the source of authority, which is the Constitution. And we should be careful, and this is really interesting for lawyers, but not so much for you, is that our federal Constitution is a source of authority. It is the grant of authority to the government of the United States to govern. But the state Constitution is not a grant of authority. That authority came from the federal government when it approved statehood in Washington. Our Constitution is actually a reservation of authority, and it says if you have all the authority as a state unless it's restricted by the Constitution. So you have to look to our state Constitution as a restrictive document as opposed to a granting document. You can't ask the legislature, well, it isn't in our state Constitution, so you can't do it. It's the opposite question. Where does it say in the Constitution you can't act in a particular way? That's about as much as we're going to go through with respect to that issue. But there's another important constitutional distinction to remember in your governance activities, and that is this. Because we have this bicameral, dual nature in our government structure, some of the things that you may want to do will not be possible in this state because our federal government and state government may be operating at different points. Obviously, marijuana is the key issue in many of your communities. Illegal under federal law, legal under state law, and frankly, the issues have not yet been resolved. Some years ago, many of you sought to set up a program to better enforce alcohol and driving, and so you wanted to set up roadblocks or checkpoints to see if drivers were properly taking care of themselves and the road and not driving while under the influence of alcohol. Our Supreme Court said that's a violation of the privacy rights of individuals in the state of Washington, and we are precluded under our Constitution from operating DWI or DUI checkpoints. The federal Constitution and our United States Supreme Court said there's nothing that would prohibit that under the federal Constitution. So as just a reminder, sometimes we have to ask the question, are we talking about the federal law or the local state laws in the Constitution? For cities, the Constitution from the outset granted you the broadest possible authority. Article 11, Section 11 of the Constitution provides that you may make and enforce within your city limits all such local police, sanitary, and other regulations as are not in conflict with general laws. All such authority that is not in conflict with general laws. First, let's talk about what that authority is. The basic authority that you're all familiar with is your sovereignty as a city government. And there are three basic elements to sovereignty. One of the most obvious is taxes. The fact is that you can tax people in your community. You have the power of eminent domain to acquire property for public use upon payment of just compensation. And, of course, the police power. These are the three elements of government sovereignty that distinguish your corporation, your municipal corporation, from Boeing or Microsoft. They can't tax, they don't have the power of eminent domain, and they don't exercise police power. But you do. And when you think about this, when you look at this list, you're looking at the list of the three things that people dislike most about government. They don't like to be taxed. They don't like it when their property is taken for a new road or a senior center. And they don't like it when they get parking tickets. But this is what government does. This is what the element of sovereignty. So even though unpopular, you always come back to a reminder of why you do exist, and that is to exercise that authority, primarily through the police power. Okay, let's go back to Article 11, Section 11 for a moment, and talk about how expansive that authority is. Under that constitutional provision, The Supreme Court has told us, and this is from a 1971 City of Kirkland decision, that this is a direct delegation. The Constitution is a direct delegation of the police power that is ample within its limits as that possessed by the legislature itself. You have the same authority within your community to act in the same manner that the state legislature may. This court said it requires no legislative sanction for its exercise. You don't need to find the specific authority in the statute, so long as the subject matter is local and the regulation is reasonable and consistent with general laws. Here's a case involving the city of Seattle some 25 years later in 1998, when the city of Seattle sought to enforce dangerous animal regulations, and some animal owners thought, well, wait a second, these are licensed activities by the state. We have some kind of state license. How can the city prohibit this? And the court said, the fact that an activity may be licensed under state law does not mean that you can't regulate it as a city. So you see these broad statements of authority that you have as broad as that of the legislature itself. And even if the fact that the state licenses does something doesn't mean that you can't regulate it yourself as a city. This will be tested very soon in the court action involving the CTAC decision by the voters to raise the minimum wage in that community to $15 an hour in contrast to the state minimum wage, a real test of city authority. Unfortunately, we also have Supreme Court decisions that tell us something different. This is from a 1991 City of Seattle decision, where the court said the city may exercise only such power as is delegated to it by the city. How does that compare with the language we just looked at? These are inconsistent statements by the court. And unfortunately, it's a fact that we have to deal with, that the court is not consistent in its guidance to us. I could be particularly skeptical and say that it's the court deciding when it likes what you do, it's going to find a way to approve it, and when it doesn't like what you do as a city, it's going to find a way to overturn it. But that can be the case in some of these particular matters. Just to conclude on this issue very quickly, the county, San Juan County didn't like the little watercraft buzzing around the nice bays and inlets, quiet communities in the San Juan counties, and adopted a law saying no jet skis, no personal watercraft in San Juan County. And the water sport industry and jet ski owners sued the county and say, how can you do this? These are licensed vehicles, vessels, under state law. Went up to the Supreme Court, and the Supreme Court said, Article 11, Section 11 requires a local law yield to a state statute on the same subject matter if that state law preempts the field, leaving no room for concurrent jurisdiction, and if a conflict exists such that the two cannot be harmonized, and found that the fact that the state licensed this kind of activity doesn't mean that San Juan County could not prohibit it, exercising its constitutional authority under Article 11, Section 11. So just as a caution there, you have broad authority as a city, but there are going to be constraints on it from time to time, and unfortunately, don't get mad at your lawyer when the lawyer tells you it may not be fully predictable of what a court's going to do about this particular matter. But we are preempted in some areas. This somewhat rude slide contains two of the most significant ones, tobacco and firearms. The city of Puyallup at one point had banned smoking in public places, and the tobacco industry put on a full-court press against the city. And the city said, we just can't afford to defend this regulation against moneyed assault by the tobacco industry and repealed that ordinance. It was a few years later that we, in an initiative, passed the no smoking in public places ban as a matter of state law, which then, of course, is in place today. But that was an area where the state had preempted local government through its adoption of particular law. More recently, we've seen this issue come up with respect to firearms. The case, there was a 2011 case cited on the slide, Chan versus City of Seattle, where the question was whether or not the City of Seattle could ban firearms in its public parks. You would think that would be something that would fall within your particular police power to regulate within your community what the public health and safety needs might be. But the court ruled in that case that the state statute 9.41.290 preempts city, and in this case the City of Seattle, from banning guns in public parks. So there are occasions of preemption when you as a city cannot act and where the state statute will trump what you would like to do. So you see in this last discussion, I've cited a court case, Chan versus City of Seattle, and I also cited a state law, RCW 9.41.290. You can always go to the MRSC website and look up any of these matters that I'm talking about today. Just go online, go to legal resources, and it'll take you to court cases or RCW, or you can look up the Washington Administrative Code just as easily. We've talked about the Constitution and the authority granted to that. We've talked about the preemption of statutes, but statutes also reflect a grant of authority. Here's one with respect to code cities, 35A 11020. The legislative body of each code city shall have all powers possible for a city or town to have. First-class cities also have the same power as code cities. We'll talk about the different classes of cities in a little bit. But just as a note, this is, again, the statutes reflecting the constitutional broad grant of authority to you to govern your best interest and your community's best interest as you might decide. Some of you have charters. A charter is your local constitution, and a charter can restrict the way you do business. It cannot grant you more authority than is conferred by state law. Charters are often organizational and procedural documents governing the structure of a particular city government. That document, Charter of the City of Seattle, for example, requires all ordinances to have a certain number of readings and a lot of procedure in them. That goes way back to the early charters of the City of Seattle in the 1800s. There are other charter cities, of course, Vancouver, Spokane, Bellingham, Aberdeen, the old cities that formed as first-class cities. Many of those still operate under charter authority. We talked about the Constitution as a source of authority. We talked about state statute as a source of authority. A charter is a potential limit on the way you exercise authority. And of course, what do? You adopt law when you adopt an ordinance. And again, the legislative authority, you may adopt and enforce ordinances of all kinds relating to and regulating local and municipal affairs that are appropriate to the good government of the city. So that's where we talk about the source of authority, the Constitution, the statutes of the state of Washington, and the federal government for that matter, and your local laws. So let's turn for a moment to what kind of city might you be.